Constitutional Enforcement Pre-Study Materials, Part 4. Imagine a 4-lane highway, 2 lanes going south, 2 lanes going north. You are on the northbound side of the highway. The right-hand lane is the slow lane and the left-hand lane is the fast lane. It's the same way with the law in this country. You've got the slow lane, that is meant for corporations, and the fast lane, that's meant for people and unincorporated businesses. Both lanes are going the same direction and serve the same basic purposes, and if one lane is closed, it's possible to limp along using the other lane to get from point A to point B. So that's what's happened. It didn't have to be that way, but that's what has been done. The courts intended to serve people and unincorporated businesses and to administer the public law have largely been shut down using the same process of surreptitious incorporation that was used to unlawfully convert our county governments and undermine our sheriff's offices. This process started shortly after the Civil War and grew out of the use of quasi-military tribunals in the southern states, where 10 military judicial districts were set up, and military common law was used to maintain order. These courts were staffed by Northerners and came to be called carpetbagger courts. The districts were placed under the direction of a brigadier or higher-ranked general, and he was responsible for appointing judges. This is a serious trespass against the civilian government, and complaints were quickly brought before the United States Supreme Court, where it was agreed that when the civilian courts began operations, the military courts would step down to their prior use and status. That decision is Milligan ex parte, and it is still in full force and effect. As usual, the general populace was not informed. In the beginning there were plenty of well-educated lawyers and judges in the northern states who maintained the civilian courts, but as the court rules began their insidious process of forcing the lawyers to accept bar membership, the old lawyers and judges who knew better died off, and with them, the civilian courts went dormant and the military tribunals crept in to fill the gap. The traffic, so to speak, was slowly being forced into one lane, and forms of law intended for corporations and corporate employees and corporate officers were being applied, incorrectly, to common people and unincorporated businesses. This process of subjecting average people to forms of law never intended for them, required the remaining courts to interpret people as things, corporations or corporate employees of one kind or another. Our civilian courts have held on by a thread and resisted conversion, just as some unincorporated counties have. One of the most common slurs I have had to overcome is the idea that I am a fake judge, but in fact, I am operating a civilian court. Page 2 of 7. Our courts prohibit bar membership just as the corporate tribunals require bar membership. As a result, the only people who can operate civilian courts are non-attorneys. Our lawyers are called counselors of law, and our judges are properly called justices. Most of our civilian courts are staffed by retirees who have chucked their bar cards and by learned laymen functioning as counselors of law. The situation has gone so far astray that ignorant people in this country assume that one has to be a bar member to be a legitimate officer of a court, when in fact, as respects the actual public law, one cannot be a bar member and hold any public office. This is the result of something else that happened in the years just prior to the Civil War. An amendment was passed to the original federal Constitution, the contract issued by the United States of America Federation to the States of America Confederation. This amendment, known as the Titles of Nobility Amendment, or TONA, prohibits bar attorneys from holding any public office in our government, and establishes stiff penalties if they do. That amendment was ratified in 1819 and is still in effect. Read that our civilian courts are in fact superior to their private bar courts in rank and legitimacy. The only justices they have are the justices of the Supreme Court, who hold the same exact rank as I do. Also read that the bar courts are deliberately kidnapping and trafficking Americans into the foreign maritime and admiralty jurisdictions they administer by falsifying records, the use of unconscionable contracts, and constructive fraud. They are, in fact, acting as accomplices to foreign incorporated crime syndicates operating on our shores, and have been for 150 years. Abraham Lincoln was a supporter and member of the International Bar Association. He was elected to serve as the President of the United States of America, our public office, but he served instead as the President of the United States, the municipal office, and Commander-in-Chief, which is a territorial office. This slick substitution was never disclosed to the American populace. As a bar member, Lincoln was prohibited from serving in any public office related to our government, so he sidestepped the issue by guile and entered into and served the foreign subcontractors' offices instead. With respect to us and our actual government, this ruse invalidates everything the Lincoln administration did for us, and it was one of the root causes of the Civil War. It is to be noted, that long prior to the Tona Amendment, George Washington did the same thing, and entered into his duties as a municipal officer, President of the United States. At the heart of all this fraud coming out of the Civil War era is a single misconception, the idea that our civilian government was impaired by or involved in this mercenary conflict at all. Take a quick look at the top-to-bottom structure of the American government. An American state national, your unincorporated county government, the Union of County Governments DBA, the United States, your unincorporated state, the Federation of State Governments DBA, the United States of America, page 3 of 7, your corporate state of state, the Confederation of State Business Organizations DBA, the States of America, your territorial subcontractor DBA, the United States of America, your municipal subcontractor DBA, the United States. What logically happens when the Confederation ceases to function? All powers delegated to it return whence they came, to the United States of America. And obviously, the delegator of the powers vouchsafed under the original federal constitution is completely competent to exercise those powers for itself. If, that is, the United States of America is given the correct information. Instead, the general populace of this country was never given full disclosure, and so, we never reconstructed the missing federal states of states, and that gave the territorial and municipal subcontractors the excuse, the emergency, that they have used ever since to prey upon us. There was no actual reason to suspend our civilian courts in the South or anywhere else at any time. What was in fact accomplished via the establishment of those military judicial districts was a racketeering scheme by which our territorial subcontractors extracted war reparations under color of law, largely from people who never participated in any war. And they have continued this criminal activity on our soil for 150 years. That our military has been grossly insubordinate and in dereliction of duty, is clear, though no doubt it comes as a great surprise to most of the officer corps and enlisted as well. Like the misinformed IRS agents and FBI agents, our military has been playing with half a deck and half an education. And that has allowed them to be misdirected and misused as cheap mercenaries in wars for profit promoted by foreign corporations and foreign governments. The Queen and the Pope have all this fraud and criminal pillaging and plundering to answer for, and to a lesser extent, so does Mr. Trump, the General Staff, and the members of Congress. All right, so that's a rundown of how we got here with regard to the court system. Let's pursue the two-lane analogy a bit further. American court system, foreign subcontractor courts, land and soil jurisdictions, sea and air jurisdictions, lawful persons, legal persons, American state citizens and nationals, British territorial citizens, municipal citizens, justices, postal judges, admiralty and commercial judges, lawful trade names, unincorporated businesses, legal names and corporation names, domestic, foreign, non-domestic with respect to them, non-domestic with respect to us. Republican states, territorial democracy, municipal oligarchy, theocracy, public law meaning, private law, unrevised United States statutes at large, statutory law, international land jurisdiction, applies to entities created by statute, federal titles and codes, the Ten Commandments, Uniform Commercial Code, soil jurisdiction, Uniform Bond Code, military regulations, administrative code, agency regulations, municipal code. As you can see, average Americans are not, generally speaking, subject to private law. Nonetheless, Americans are being routinely misaddressed as foreign federal subcontractors and subjected and defrauded using false legal presumptions under foreign forms of law that do not legitimately apply to them. Unless Americans are actually employed by the U.S. military or the Federal Civil Service, or are serving as elected officials of the territorial or municipal governments, or working for legitimately constructed U.S. corporations, knowingly seeking political asylum, knowingly seeking federal welfare benefits, with full view of the costs, or born in actual territories, they cannot be considered territorial United States citizens, nor can they be considered municipal citizens of the United States. You have seen one example of how Americans are being deliberately impersonated via falsification of records held in IRS master files, my own example of being misidentified by the IRS as a rum-running mama from Barbados, which is used as a pretense to address me as a British territorial U.S. citizen engaged in the manufacture of a taxable controlled substance, and therefore, subject me to the private IRS tax code. That is just one such gambit used to impersonate and attack and defraud Americans. The principal mechanism used to create a foundation for all this fraud is what I call the dead baby scam. It's all a little bit more complex than this, but basically, when we are born in an American hospital, a doctor who has been illegally conscripted and licensed by the territorial United States government takes the dying amniotic material, the placenta and related afterbirth, attaches our given name to it, admits it to the hospital record as a dying person, and signs a birth certificate. Ironically, this birth certificate is used as our death certificate, and the entire process is used to create an intestate infant decedent estate trust. The estate created under the name of this non-existent dead infant is purportedly abandoned by the actual owners when they don't take the placenta and other afterbirth materials home, and so it becomes property of the state organization issuing the birth certificate. Thereafter, this whole rigmarole is used as a device to latch onto and administrate your identity, use your name, and seize upon your assets using dead letters of administration issued by the incorporated county circuit courts to members of the bar associations. So it all comes back to the foreign territorial and municipal corporations that are supposed to be providing us with governmental services, and the officers of the foreign subcontractors courts, the members of the bar associations, and American doctors who are being suborned and forced into licensing agreements by the AMA, just like the lawyers are being suborned and coerced under the court rules. If you want to work in your profession as a doctor or a lawyer, you have to play their game. Or so they say. Actually, neither profession is subject to licensing in America. It's another scam and another story, but this is how the rats are stacking things and kidnapping Americans on paper and trafficking them into their foreign jurisdictions and then fleecing them in their equally foreign courts. The criminality of this is self-explanatory. The fact that it is all gross constructive fraud is self-evident. Those of you who are employed in any position related to law enforcement, take note. This is a national-scale identity theft scheme that has been used to access our credit, seize upon our assets as chattel backing the debts of these foreign governmental services corporations, and leave us holding the bag for it. Note also that every birth certificate is evidence of the aforementioned crimes. The birth certificate is issued long before the remainder man, the living baby, is even possibly aware of what is going on. This creates an unconscionable contract, literally a contract that you are unaware of, and can't object to, because you are unaware of it. Such contracts are fraudulent by definition, both illegal and unlawful, null and void. But day after day, all across America, false legal presumptions provided by this process and these abhorrent contracts, are being used to strip assets from Americans. And it's happening on the watch of all the various police forces and on the watch of the American Armed Forces, but it's not happening under my watch. It's the duty of all federal employees, including state-of-state franchise employees, to support and defend the states and the people and the United States of America, the unincorporated version thereof, but instead, our foreign federal subcontractors operating as commercial corporations, have been acting as crime syndicates. Obviously, this situation requires diplomatic outreach and broad-spectrum public exposure. It also requires enforcement of the public law. Our law, the unrevised United States statutes at large and the Ten Commandments. And also enforcing our side of the constitutions. That is where the loyal soldiery and you fellows and the national militias and our state assemblies and the restored American civilian courts, come in. Until we start arresting these criminals and putting them in jail, they have no motivation to stop their racketeering, pillaging and plundering, but it isn't as simple as walking into one of their courtrooms and arresting everyone. It isn't as easy as going into the maternity ward or the hospital records or the vital statistics office and physically invalidating everything we find there. It isn't even a matter of arresting their state-of-state governor. We have to educate the President, the Joint Chiefs, the United Nations Secretary-General, the Pope and the Queen, all of whom inherited this situation. We have to educate doctors and lawyers. We have to educate judges, many of whom think they are doing their duty. We have to educate the armed forces and millions of American civilians. At the same time, we are educating county politicians and taking peaceful and responsible action to bring a halt to these crimes of fraud and predation. About now, you are wondering, how do we do that? End part 4.